Going to continue pressing on with note cards starting with the immunities, state and local government. States have sovereign immunity under sovereign immunity clause of the U.S. Constitution may limit its immunity when it chooses to waive its immunity. And a good example is Clark versus the Oregon Health Sciences University case. Tort liability against a municipal governmental unit for negligent conduct may be imposed where the government unit is negligently providing the service and the plaintiff had relied on the government's assurances. So, that's just established in DeLong versus Erie County. And just to display those elements in practice, the case where the government unit was negligently providing a service, that service was a 911 telephone response where they didn't follow their own standard procedures and didn't respond to a burglary that did turn into a tragic death. And so the government negligently provided this service, and it may have not been talked about here, except for that the plaintiff had relied on the government's assurances. So the government doesn't necessarily have a duty to provide. The two cases before this case were about a plaintiff coming or a victim coming to the police and asking for special protective services because they had stalkers, etc. And the police neglected to provide those protective services to the victim who ultimately was attacked. And the government doesn't, and the government serves the public at large, doesn't serve any one particular member of the public, which is why it is said that the government does not owe the victim here a duty. It owes the public a duty, within the bounds of its limited resources. However, when DeLong called the 911 relay service and they indicated that an officer was on the way, they offered a special service, which means that they undertook a duty to the plaintiff, and that was breached negligently because they did not get her address correct or read it back to her according to standard procedures, and the service was not provided. So the duty was breached, and by not being there when the plaintiff had expected them to be there and maybe stayed in her house when she probably could have escaped and ran, she stayed in her house and waited for the police to come, and in doing so sealed her fate. So in this municipal government unit case, the defendant was found liable. So for statutes of limitation and repose, for the majority of jurisdictions, the time of the accrual of the statute of limitations is usually set forth in statute for a year or 2 years from the injury or the harm sustained. However, the majority of jurisdictions have developed a discovery doctrine, and for purposes of the statute of limitations, what that means is the cause of action accrues when the plaintiff discovered or should have discovered the negligently inflicted injury rather than at the time of the injury. And this is demonstrated in Teeters versus Curry. For the traditional common law rule on the statute of limitations, which is followed in the minority of jurisdictions, a cause of action accrues with the infliction or occurrence of the injury. In mere ignorance or failure to discover the cause of action on the part of the plaintiff does not toll which means stop the running of the statute of limitations. I'm just going to take a moment to just show you a current event that I found in a magazine on the topic of law. As you can see, she's reading torts and using a Black Laws dictionary. And this is the number one thing to do on the must list is study and catch some sun rays. Work on a tan. Which I haven't been doing. Vicarious liability. The negligence of one party may be imputed to another because of the relationship. And this is first demonstrated to us in the case called Boussard versus Minimed. Respondent superior. So set forth is the employer's negligence will be imputed to the employer if A, the employee is acting within the scope of his employment at the time the conduct occurs, and B, the employer is exercising control over the employee, and that includes commuting to work. I'm sorry, that does not include commuting to work. There's a, coming and going defense that is not generally considered to be within the scope of the employee's work, the coming and going to and from work. However, if the employee, say, uses a car has to travel for their job, then there's a frolic or detour doctrine that will hold that whether the employee is on a frolic of his own or had merely taken a detour is a question of fact that ordinarily must be resolved by a jury. And this was demonstrated in O'Shea versus Welsh, where, let's just say branch manager, for lack of understanding what this guy was actually employed in, but the branch manager was bringing tickets, maybe one of the customers won a lottery or something, and he was bringing tickets to another branch, let's say. And in the process thereof, he made a split decision to pull into a rest stop where he was actually going to get his car inspected. And it's up to the jury to decide whether that would be a frolic, meaning for his own purposes and not for the bank or his employer's purposes, or if it was a detour, meaning he needed to, say, stop at this rest stop to for his own comfort. And so a frolic, we'll say what detour is first, is a slight deviation from the employer's purposes for the convenience of the employee for which the employer is responsible for the employee's negligent conduct. Forgot to mention that he got an accident when he was pulling into the rest stop. So a frolic, on the other hand, is more than a slight deviation from the employer's purposes for which the employer is not responsible for the employee's negligent conduct. So if he was really going to take his car in for an inspection, it probably would have taken a couple hours, maybe one at the least, which would be like a lunch break still. So I would have a hard time as a member of the jury saying that I was going to hold his employer responsible for his accident when he pulled into the service station. Restatement 2 of agency, section 237, a slight deviation is defined as personal acts that are not far removed in time, distance, or purpose from the employment and are deemed to be incidental to the employment. So that would be your detour. That would be your slight deviation from the employer's purposes for convenience of employees for which the employer is responsible for the employee's negligent conduct. Whereas frolic is more than a slight deviation from the employer's purposes for which the employer is not responsible for the employee's negligent conduct. Again, slight deviation is the personal acts that are not far removed in time, distance, or purpose from the employment are deemed to be incidental or to the employment. Again, so let's just go over vicarious liability. This is I guess another way to refer to respondent superior. So the negligence of one party may be imputed to another because of the relationship. So actually, respondent superior is like a subset of vicarious responsibility. Like, I feel like if your son or daughter hit someone with like your car, you're responsible. But I feel like we didn't go over cases like that showed anything besides respondent superior, where like the let the master answer is what that stands for. Independent contractors, though, I guess is another example of vicarious liability. And so a person, employer, is not liable for the actions of an independent contractor, as demonstrated in Miller-Goertz. The exercise of control is not adequate to justify liability. So the employer is not responsible for the actions of the independent contractor in most cases, but I think the case that they're referring to right now is the case where the owner of a vehicle that had been worked on by a auto mechanic, who they're referring to as an independent contractor, had a problem and caused an accident, and they held the owner of the vehicle responsible, saying that this was a non-delegable duty, which appears that maybe Merrill versus Goertz is the wrong case, because non-delegable duty is right beneath this concept of independent contractors not imputing liability upon the principal, and under non-delegable duty, you see that the person upon whom the duty is imposed is responsible for the independent contractor's actions in negligently performing the duty. And this was from the Maloney versus Rath case. Certain duties cannot be delegated. The person who owes the duty remains responsible even though some other party has been retained to fulfill that duty. So the duty is to keep your car or motor vehicle in operating order, and you can't put that duty on your auto mechanic. It's your responsibility to make sure your car isn't going to cause a accident. But if you truly are not at fault because you just got your brakes fixed or whatever, you can then turn around and sue your auto mechanic for negligence and recover, or for contribution, or for indemnity. It just kind of depends what applies. So the joint enterprise doctrine. Vicarious liability may be imposed upon those engaged in a joint venture. This is from the Popejoy versus Steinel case. And Popejoy versus Steinel was kind of a gruesome case, but I'm not going to actually go into it. No, I kid. Okay, in the Popejoy versus Steinel case, Steinel is a mom in a ranch family, and her husband buy their daughter's cattle to take care of on their ranch. That cattle don't belong to the ranch, they belong to the female children. And in the process of picking up a cattle, Mrs. Steinel hits Popejoy, and Mrs. Steinel dies, and Popejoy lives and doesn't realize that he's has sustained injuries as serious as they are, and within a couple of years has to undergo serious surgery. And Popejoy decides to sue Steinel, not Steinel's estate, and not Steinel's husband's estate because her husband had passed since. He tries to establish a joint enterprise under the joint enterprise doctrine, that like the husband. Okay, yes, because the female's estate had already been settled and closed. So he tries to say that the husband and the wife were part of a joint enterprise, and that the cattle that they were in the process of picking up when the accident occurred was a joint enterprise. However, joint venture requires a couple things that were proven not to occur in the facts. So this was not, it didn't meet the third element, which was a community of pecuniary interest in the joint enterprise among the members, because the husband wasn't getting anything from this. Really, it was a gift that was going to the daughter. So a joint venture, in short, is a venture where there is an agreement, express or implied, among members of a group to act with a common purpose to enhance their pecuniary interest, and in which they have equal control over the direction of the enterprise. And when you break that down in elements, as happens to be referring to Section 491 of the restatement, it says, "And an agreement, express or implied, among members of a group," which is like greater than one person, and a common purpose is to be carried out by that group, and there's a community, a pecuniary interest in that purpose among the members, and lastly, an equal right to a voice in the direction of the enterprise, which gives the right, equal right of control. Strict liability is the next lovely section here. There's a section on animals. There's a section on abnormally dangerous activities, and before we move on to like limitations, and then finally products liability, which generally is strict liability. So for animals, trespassing animals, particularly, strict liability for reasonably foreseeable damage is like placed on the trespassing animal's owner. Non-trespassing animals, if they're wild and they're not like indigenous to the area, there's strict liability for harms caused by an animal's dangerous propensity. Meaning, there's strict liability for harms caused. Yeah, harms caused by the animal, and because the animal is inherently has a dangerous propensity because it's like not from the area. If it's a domesticated animal, if it's a domestic animal, there will be no strict liability placed upon the owner. However, if the owner knows or has reason to know the animal is dangerous, then strict liability will be placed on him. So if he puts up a sign that says "Beware of dog," then that shows that he is knowledgeable about his dog having a dangerous propensity, and that can actually render him strictly liable for any damage that his dog may cause. And some jurisdictions will require that the dog at least do one thing to have one experience that would set the owner on notice that the dog has dangerous propensities. Some dogs, sometimes by their breed, have dangerous propensities according to statute. So abnormally dangerous activities generally constitute strict liability on the person who is undertaking the activity, and a person is strictly liable for any harm which occurs while engaged in an abnormally dangerous activity, so long as the harm results from the kind of risk that made the activity abnormally dangerous in the first place. Safety precautions taken by the defendant defendant are completely irrelevant, and that's not really a fair statement, but let's read the rule of law just one more time. A person is strictly liable for any harm. So if he's taking safety precautions, then likely he's reducing harm and he's not going to even be going to court in the first place. But let's just say a person, nevertheless, any harm caused, and he goes to court for it, he is held strictly liable for that harm, which occurs while he's engaged in the abnormally dangerous activity, as long as the harm results from the kind of risk that made the activity abnormally dangerous in the first place. So likely, if it's demolition, we're talking like property damage, or like damage from like blasting, if that blast were to be out of control. So, and hit someone walking by. So, it doesn't necessarily cover risk of like scaring your bird into flying away. Because that is not the kind of risk that the activity that makes the activity abnormally dangerous. Factors for determining abnormally dangerous activity is a high degree of risk of serious harm. That risk cannot be eliminated. For which that risk cannot be eliminated. So the defendant may be held liable for damage caused by the non-natural use of the land, even if there is no negligence on their part in causing the damage. So this is like the founding case of strict liability from Rylands versus Fletcher. And, there was a mine underground, and let's just say that some natural act caused that mine to flood. The owner of the property wouldn't be liable to like the miners. However, when the owner decides to like put a dam up or like something to his property, which is a non-natural use of the land, and even if he did so without negligence, the fact that it inevitably caused this mine to flood is going to make him strictly liable. I haven't seen a case like this in the other cases that I read in the strict liability section that I can compare this to about the non-natural use of land. But that's where we get our concept of strict liability from, which is liability without fault this time, which is a really poor definition of strict liability. So I'm going to see if I can possibly find it again. The definition of strict liability ain't given. So, anyways, actually, this might be the rule right here. One who carries on abnormally dangerous activities is subject to liability for the harm to the person, land, or chattels of another resulting from the activity, even though he has exercised the utmost care to prevent the harm. Factors of whether an activity is abnormally dangerous, from Miller versus Civil Constructors Incorporated, is 1, the existence of a high degree of risk of some harm to the person, land, or chattels of others. 2, likelihood that the harm that exists from it will be great. 3, inability to limit the risk by exercise of reasonable care. 4, the extent to which the activity is not a matter of common usage. 5, an inappropriateness of the activity to the place where it is carried on. And 6, extent to which its value to the community is outweighed by its dangerous attributes. So let's just read that craziness again. Existence of a high degree of risk of some harm to the person, land, or chattel of others. likelihood, too, that the harm that results from the activity will be great. 3, the inability to eliminate the risk by exercise of reasonable care. And 4, extent to which the activity is not a matter of common usage. 5, inappropriateness of the activity to the place where it is carried on. And lastly, extent to which its value to the community is outweighed by the dangerous attributes. So it doesn't really apply, but like, let's just say, actually, here's where it might apply. If we're talking cleanup efforts and somebody gets hurt, so like we're cleaning up a natural disaster and our measures are abnormally dangerous and somebody is hurt, well, the value that that cleanup effort is bringing to the community might outweigh its dangerous attributes. Anyhow, let's move on. Strict liability limitations. Under strict liability, the plaintiff may recover only for the type of harm that makes the activity ultra hazardous or abnormally hazardous and thus subject to strict liability. See Foster versus Preston Mill Company. So again, the plaintiff may recover only for the type of harm that makes the activity ultra hazardous and abnormally dangerous and thus subject to strict liability. So not your cats killing their young because they're afraid because of the noise that you're making. Anyhow, no recovery for strict liability if the harm was caused by an unforeseeable event. We're citing Golden versus Amory. The strict liability does not apply to situations where the defendant could not have anticipated the risk to which the plaintiff was exposed. That might be the cat case. I'm not really sure. Contributory negligence is not a defense to strict liability in some jurisdictions. However, assumption of the risk can be a defense in the same jurisdiction, so long as it was a voluntary and knowing assumption of the risk. So what we're saying is, if you're holding someone strictly liable, which is kind of liability without fault, which is kind of liability without negligence, then to say that the plaintiff's contributory negligence, like contributed to the accident, and that the defendant should be held or should be able to rely on that contributory negligence as a defense against in a court of law, protecting them from having to pay like at least the full amount, or in the case of contributory negligence, any damages whatsoever, is kind of not doesn't make sense, because strict liability isn't based on negligence, so it's hard to have a defense blaming the plaintiff for negligence that contributed to an accident that was already highly probable. Assumption of risk, however, can be a defense in the same jurisdiction. So generally, if you can say that the plaintiff was contributorily negligent, you also might be able to say that the plaintiff assumed the risk in that very same jurisdiction. But generally, you're not going to say like one or the other. You're going to see them together because they've kind of been bundled. And so long as the plaintiff's action was voluntary, and he also knew that he was assuming the risk. Because you can't, if he had no choice but to assume the risk, that's not going to be something defensible, because it wasn't voluntary, it was necessary. those are the limitations on strict liability. So moving into products liability, I really feel like a little bit more on assumption of risk would be nice. I might have wrote that down yesterday. No, I wrote down indemnity. Okay. So assumption of risk theory for a defense is a good one to have. So is the definition of strict liability, which I wasn't really detecting in my notes provided by the professor, which is fine. It's not his job to give us everything. So in products liability, this is an area of law where your role of counselor is as important or perhaps even more important than your role as advocate. Outside counsel, lawyers, engineers, and human factors experts work with responsible companies to try to assure that their designs and warnings will not result in the accidents that expose them to liability. This is about risk prevention. And starting with product liability based on negligence. A manufacturer of a product is liable for injuries even though there is no relationship between the manufacturer and the user, which skips past the dealer to the user, which I guess, that was done for, in order to make it easier for the plaintiff to recover, that he doesn't have to first sue the person who sold it to him and sue the person who sold it to the retailer, and then after suing, say, like the distributors, the wholesaler, and then like from the wholesaler to the manufacturer. This allows him just to, without having a privy of contract, he can still recover for damages sustained from like defective product. So that's kind of the pretext for what we're going to discuss right now. Warranties, express warranties and implied warranties. Those are generally in your contract. But since this occurs without a contract, a lot of times we work with implied warranties to form products liability between the manufacturer and the buyer, because generally the product is supposed to be fit for use, and if it's not, then we'll go to court. A lot of times we'll talk about a breach of an implied warranty, that the product, if it's on the market, it ought to serve the purpose that it appears it's intended to achieve. So products liability, strict liability. California adopts strict liability for defective products due to its view that negligence and breach of warranty are not adequate causes of action to compensate the plaintiff in a cause of action based on harm caused by a product. And this came from Greenman versus Yuba Power Products. So that's like a really stupid way to put this, but California adopts strict liability for defective products, like so does every other state, because this is in the, I feel like this is in the restatement. In fact, it's right here in the restatement. I'm just going to skip past that statement that he said from Greenman versus Yuba Power Products, saying that California adopts strict liability for defective products due to its view that negligence and breach of warranty are not adequate causes of action to compensate the plaintiff in a cause of action based on harm caused by the product. So what he's trying to say is that this new liability theory, strict product liability theory, is a more adequate way to compensate the victim than formerly you would have if the plaintiff brought negligence or a breach of warranty cause of action against the defendant for harm caused by the product. But in the restatement, it's not said that way. In the restatement, section 402A, there's a special liability of seller of product for physical harm to the consumer, user or consumer. And so, one, under Section 402A, is that one who sells any product in a defective condition unreasonably dangerous to the user or consumer or to his property is subject to liability for physical harm thereby caused to the ultimate user or consumer or to his property if A, the seller is engaged in the business of selling such a product, and B, it is expected to and does reach the user or consumer without substantial change in the condition in which it is sold. So that's part one under the restatement. One who sells any product in a defective condition unreasonably dangerous to the user or consumer or to his property is subject to liability for physical harm, thereby caused to the ultimate user or consumer or to his property if the seller is engaged in the business of selling such a product, and it is expected to and does reach the consumer or user without substantial change in the condition in which it is sold. So like your automobile dealer didn't like attach some crazy hydraulic like system that like broke the brakes. So anyway, part two under the restatement is the rule stated in subsection 1 applies although A, the seller has exercised all possible care in the preparation and sale of his product, and B, the user or consumer has not bought the product from or entered into any contractual relation with the seller. So the rule stated in subsection 1 applies although A, the seller has exercised all reasonable care in the preparation and sale of his product, hence the strict liability because it's not based on negligence. What we're saying here is that the defendant could have very well exercised all possible care in the preparation and sale of his product, and he's still going to be liable if subsection A 1 applies, and also B, the user or consumer has not bought the product from or entered into a contractual relation with the seller, like I said before, and provided the reasons why. Product liability proof. So in evidence, let's just go through evidence. Something is very different from proving it, okay? And the defect may be proved by circumstantial evidence. That came from Friedman versus GMC. Okay, thank you. There's a couple different kinds of defects of products. There's a warning defect, a manufacturing defect, and a design defect. In the warning defect, let's go with manufacturing defect. A seller of a product will be strictly liable for products in a defective condition unreasonably dangerous to the user or consumer that cause physical harm. So the seller of the product will be strictly liable for products in a defective condition unreasonably dangerous to the user or consumer that causes the user or consumer physical harm. And the product is defective in manufacture if it does not conform in some significant aspect to the intended design or to the other products made to that design. So that makes it a manufacturing defect. And now let's go into a warning defect. A good warning should accomplish A, B, and C. Should 1, get the user's attention. 2, explain what the hazard is. For example, it may cause blindness. I can speak. Blindness. And 3, show the user how to avoid the risk. For instance, only use outdoors. In California, the plaintiff must demonstrate that the defendant had actual or constructive knowledge of potential risk or danger that caused the injury to the plaintiff in order for the court to impose strict liability in a case on failure to warn. So the plaintiff must demonstrate that the defendant had actual or constructive knowledge of potential risk or danger that caused the injury, the risk of danger that caused that particular injury to the plaintiff in order for the court to impose strict liability in the case on failure to warn. Super. This comes from an Anderson versus Owens Corning Fiberglass Corporation. I don't even want to get into it. Some idiot dove into a above ground pool and said that. Well, they tried to say it was a a warning defect 1 because, like, I guess he didn't notice the sign, and he also wasn't smart. He probably wouldn't be looking for a sign in the first place. But second of all, he tried to call it a design defect, that the bottom of the pool should have been more slippery, so that, no, not slippery, should have been rubbery and not slippery, because it being slippery is what made his hands move from protecting his face when he dove into the bottom of the pool. But the company was like, no, we don't want a rubber bottom, we want a slippery bottom for other reasons. But anyway, that would be a design defect, which, unusual as it seems, is just not here. So I'm gonna write design defect on a note card. All I'm seeing here is defenses to product liability, which is comparative negligence principles apply to products liability causes of action based on strict liability. So you're not going to see contributory negligence, you're going to see comparative negligence used as a defense to strict product liability. And the plaintiff misuse of a product will not prevent recovery under a strict liability theory of recovery if the plaintiff's abnormal or unintentional use of the product was or should have been foreseeable to the defendant. So, I think it's reasonably foreseeable that some idiot is going to dive into, like, an above-ground pool. That's foreseeable. So they probably need to put more signs up if they weren't readily apparent. But there's some types of products where people find very creative uses for them, not intended by the design and the designer, and if they end up hurting themselves in doing so, if the product designer had no idea that his product is going to be used that way, then generally that's a defense. So for nuisance, a legal action to redress harm arising from the use of one's property. You have two types, private and public. For a private nuisance, this is a civil wrong. It is the unreasonable, unwarranted, or unlawful use of one's property in a manner that substantially interferes with the enjoyment or use of another individual's property without an actual trespass or physical invasion to the land. A public nuisance is a criminal wrong. It is an act or omission that obstructs, damages, or inconveniences the rights of the community. Nuisance. Again, continued, private. In a cause of action intended to protect neighbors to the nuisance, not owners of the nuisance, even where the owner of the nuisance did not create it. So this is a cute summary of the Pico versus Hercules case. A really tough case to sum up in one sentence. That's all I gotta say. But if I must, since it's my hometown, sort of, in the area of Chester, Pennsylvania, there's really low property values. I wouldn't say it's all Pico's fault. I would just say that it's really very like industrial looking on the side of the Schuylkill River, and that's where like power is generated, and for a long time. But that property was sold by Pico to, or assigned to someone who it was then assigned to Hercules, who is the defendant. And Pico is, I think, still the next door neighbor. And In fact, I think originally Pico was renting the property to Picco, Picco, that was doing, which was dealing with resins. The resins turned up in an environmental test to be polluting the Schuylkill River, and the environmental, like Pennsylvania's environmental department, required Pico to clean it up, which cost them about like $400,000, which is nothing, but especially probably at the time of the case. But Pico wanted to recover his damages from the now owner of the property, and he also wanted an injunction to stop the now owner of the property from, whatever it was that's causing, or may still exist, causing the resins to pollute the Schuylkill River. And he brought a private nuisance in order to do it. And again, going back to what the definition of private nuisance is, this would be a civil wrong. It is unreasonable, unwarranted, or unlawful use of one's property in a manner that substantially interferes with the enjoyment or use of another individual's property without an actual trespass or physical invasion to the land. So the usage of this property, or former uses of the property that omits the pollutant into the Schuylkill River, is the civil wrong, is unreasonable, unwarranted, or unlawful use of one's property. But we don't know who can bring a cause of action against Hercules for that, because the harm isn't like to another individual's property without an actual trespass or physical invasion to the land. Like, Pico can't say that his land was being polluted. He can say that the Schuylkill River is being polluted, which is which is a river. And so, this probably would have been better brought as a public nuisance, which is a criminal wrong. But that's a criminal wrong, which is probably why it wasn't brought. And it is an act or omission that obstructs, damages, or inconveniences the rights of the community. So I think Pico was trying not to go that route and was just trying to get a verdict by private nuisance, because there was a special, and this is something that came out of this case, there was a special damages to Pico. And so that's like kind of an exception that allows them to bring private nuisance. However, they weren't really allowed to bring a private nuisance, because when they bought the property originally, I think the court was trying to base that. When they originally bought the property, they bought it at a significantly reduced value, which was most likely due to environmental conditions. So if Pico didn't pay for the full value of the property, he paid less the environmental conditions, then he's probably going to have to pay for the environmental conditions eventually, which is, I think, what happened here. The court felt that, it's time to pay for that, rather than to place that burden on the person who ultimately now owns the property, who is known as Hercules. And public nuisance, further, in an individual action for public nuisance, pecuniary harm may qualify under the restatement second 821C2 as a harm of a kind different from that suffered by the general public, but to support a successful claim, the pecuniary harm must have been suffered as a result of an individual's exercise of the common right to the general public. I think this has to do with the same case, I think. So let's just read it again under public nuisance. Further, so under private, it says, private nuisance is a cause of action intended to protect neighbors to the nuisance, not owners of the nuisance, even where the owner of the nuisance did not create it. All right, so the owner of the nuisance didn't create it. So Hercules didn't create the environmental issue. Anyway, public nuisance. Further, in an individual action for public nuisance, pecuniary harm may qualify under the restatement as a harm of a kind different from that suffered by the general public, but to support a successful claim of pecuniary harm must have been suffered as a result of the individual's exercise of a right common to the general public. I feel like this is a great case because it has to do with like Pennsylvania, outside Greater Philadelphia area, but it really is not very good one for demonstrating nuisance. I would really rather see a plain vanilla one, like we're Canadians and we're inhaling what's emit from like 7 different factories in like New York and going over like the Great Lakes and poisoning us, and now we're all gonna like bring an action against these factories. That's a public or a private nuisance? If it was a public nuisance, it would be a criminal wrong, act or omission that obstructs, damages, or inconveniences the rights of the community. So I have a right to be able to like live healthy and breathe the air that is natural and be healthy. Whereas a private nuisance is a civil wrong and is the unreasonable, unwarranted, or unlawful use of one's property in a manner that substantially interferes with the enjoyment or use of another individual's property without an actual trespass or physical invasion to the land. So I might say that if I'm breathing the air and I'm getting sick and I live there, that I'll probably bring a private nuisance. But if I just work there, I don't live there, I don't own there, I might bring public nuisance. Anyway, what private nuisance was used for the most part in our books had to do with like an odor omitted from like agricultural activities nearby residential neighbors. So a nuisance is the use of property unnecessarily interfering with the use and enjoyment of another's property, may be intentional or negligent. And we're quoting the Morgan versus High Penn Oil case. A lawful enterprise cannot be a nuisance per se or at law, but can become a nuisance per accidens or in fact without being construed or operated in a negligent manner. Further, an invasion that arises to the level of private nuisance may be either unintentional or intentional, and an intentional invasion resulting in injury to others gives rise to liability regardless of the degree of care exercised to avoid injury. It doesn't give the case here, but the case has to do with like a plutonium factory or something. Oh no, maybe this is High Penn Oil. Okay, so it's an oil refinery, and this one time there was an accident that made it particularly odorous at a particular time nearby Morgan, who happened to own like a couple of acres being used as like a trailer park, let's just say, for lack of better words. And his house is there, and then he has a business there too. And so it was kind of like nauseating, the smell that the oil refinery was letting off because it had an accident. And that accident occurred in a negligent manner. However, nuisance in this particular case is kind of being broken down into an intentional or an unintentional act, into a negligent or a intentional act. And just to read that again, just to like kind of hammer that home, a lawful enterprise cannot be a nuisance per se or at law, but can become a nuisance per accidens, or in fact without being construed or operated in a negligent manner. And further, an invasion that rises to the level of private nuisance may be either unintentional or intentional, and an intentional invasion resulting in injury to others gives rise to liability regardless of the degree of care or skill exercised to avoid injury. To determine whether a nuisance exists in an action for damages, courts should consider the interest of the community. One factor to be used to determine the interest of the community is the utility of the conduct. Harbner vs. Double R Cattle Company. Equitable power of the court. Where there is a large disparity between the harm caused by the nuisance and the economic factor of an injunction to abate the nuisance, and where the nuisance is permanent and unabatable, the court has the equitable power to substitute permanent damages for both past and future harm in place of an injunction. So, this place in Albany called Atlantic Cement Company, we're releasing like cement into the air and is making the air, a nuisance for the neighbors. And so Boomer brought an action against this cement company. I guess this is just neighbors. And so instead of allowing this injunction, which would really be unequitable because first off, I think the cement company had like millions of dollars of investment in it, and to shut it down and tell them that they can't produce cement there would be really uneconomical just for like the enjoyment of the land by a couple of the neighbors. So further, like, the judge said, you know what, we would love to be able to say, like, why don't you make your activity more safe for those around you? But at the time of the case, there really wasn't a solution. And so they said, we're going to do this other thing to abate rather than an injunction to abate the nuisance. What we're going to do is exercise our equitable power to substitute permanent damages for both past and future harm in place of an injunction, which is like this brand new thing. But they feel as though environmental concerns are one that should be addressed by legislature and not decided upon, in a vacuum, meaning case by case. This is something that they would expect, the state or the local government or, the country as a whole to start regulating, and didn't want to do it in this case. So they did something else where they allowed, they exercise an equitable power to substitute permanent damages for both past and future harm in place of an injunction, which is truly novel. I don't know how that's because I don't know if that's allowed under legislation. But anyway, by the ability to continue the nuisance is what that translates into. A residential landowner who comes to the nuisance may not have release if he knowingly came into a neighborhood reserved for industrial or agricultural endeavors when he is damaged thereby. But where the public interest was at stake,